characteristics of a republic, there must be, the people must be the source of authority. And that's what the Constitution of Uganda says. Everything is done in the name, for, and in the name of the people of Uganda. The people must also elect their representatives to make laws and serve their interests. And that happens through parliament. In a republic, there must be rule of law. Law that applies to everyone equally. And this will be very important in an issue that I'm going to raise. In a republic, there is protection of rights. The government protects the rights of citizens. Another feature of a republic is the absence of a monarchy. A monarchy is where leadership is hereditary and to families. There is also equality of rights. All citizens have equal rights. Those are some of the characteristics of a republic. Uganda being a republic and having representative democracy and having a constitution that protects the rights of the people, this court-martial is enjoined to follow the constitution. So what does the constitution say on the reference of constitutional questions to the court, to the constitutional court? I want to read Article 137, subsection 5, where any question as to the interpretation of this constitution arises in any proceedings in a court of law other than a field court martial. And I want to pause there and say this is not a field court martial. This is a general court martial. So this section applies to this general court martial. The court may, if it is in the opinion that the question involves a substantial question of law, the court shall, if any party to the proceedings requests it to do so, refer the question to the Constitutional Court for the decision in accordance with Clause 1. So you can refer the matter of your own accord. But when it is requested by a party, the way now we are requesting you on behalf of these two gentlemen, Dr. Besige and Mr. Rutale, you have no leeway. You are commanded by the Constitution to refer the matter to a constitutional court. The matter, as my colleagues have canvassed, arose in the course of your ruling, Mr. Chairman. And I will not go to the questions they have already framed. I will go straight away to a different question, the question of freedom from discrimination, in line with Article 21 of the Uganda Constitution. When there is no law to define who in Uganda chooses to bring civilians like Dr. Besige and Mr. Rutale to the General Court Martial instead of the courts of judicature, that subjects them to discrimination, and it is our prayer that this question be added, whether it is discriminatory to bring civilians to a general court martial instead of a court of judicature, especially without a defined authority that makes that choice. Because the question we are asking, who made the choice? We do not know. The charge sheet does not tell us. There is no gazette notice to tell us that XY is the one who made. We can only guess that authorities within the military decided. But it's an authority we cannot touch. It's an authority we do not know. And in a democracy, discretion and power is limited by the Constitution and laws. There is nothing in this Constitution prescribing how, who and how the decision to bring civilians to a court-martial is made. Therefore, when they are brought at the whims of people we do not know, authorities not defined, it becomes discriminatory. We want the court to answer whether indeed this is discriminatory, as we state from the bar. My colleagues have already argued that the fact that the offenses for which they are being tried are not defined is again something the Constitution abhors. And I've already said constitutions exist to limit exercise of power. So if exercise of power is not limited by the Constitution, then it is unconstitutional. And the court, the Constitutional Court needs to answer that question. I also want to add one more article of the Constitution, that Article 79 of this Constitution of Uganda, which mandates Parliament to make laws. It defines the functions of Parliament, and it says that subject to the provisions of this Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda. Except as provided in this Constitution, no person or body other than Parliament shall have the power to make provisions having the force of law in Uganda, except under authority conferred by an act of Parliament. And then finally, Parliament shall protect this Constitution and promote democratic governance. So the exercise of power to cause civilians to come to a general court-martial are not defined in any law, and therefore they are unconstitutional and against Article 79. And we are asking you, in framing that question, whether we can have exercise of power without, or discretion without limit, is unconstitutional. Add Article 79 to that request. Finally, everybody, including yourselves, is obliged under the Constitution of Uganda to obey it. So we are urging you to stand up for the Constitution and to refer these questions to the Constitutional Court so that we can have finality. Maybe somebody may argue that because others have taken the questions to the court, to the Constitutional Court, they have already been answered. I want this General Court-Martial to note, we have raised questions that have not been raised before. There are some that may be similar to those that have been raised earlier. Questions of discrimination, questions of a lawyer who is part of the team being arrested and detained and therefore not available, questions of fair process. There are quite a number of questions that have not been asked before. Also the fact that there is nothing in the Constitution that gives the UPDF judicial authority over civilians. And therefore, any act of Parliament conferring judicial authority on civilians to the General Court-Martial is unconstitutional. So it's a question the court will have to determine, to declare the UPDF Act unconstitutional to the extent that it confers judicial authority on civilians to the UPDF. And Mr. Chairman, when you are reading your ruling, you actually found that it was not, you alluded that it was not unconstitutional. The authority to interpret the Constitution is exclusively to the Court of Appeal, sitting as a constitutional court. So it will be useful even to you and the General Court Martial to hear an authoritative interpretation from the Constitutional Court as to whether you indeed can try any civilian in Uganda. The issue of extradition from Kenya, not extrajudicial rendition, not extradition. Extradition connotes a court process where orders are made. In this case, there was no court order. We urge that those issues are more than enough, and I'm asked by my colleagues that since we have exhausted, we end it here to give the prosecutor the chance to make a rejoinder.